All right, it's time, everybody. Welcome to Big Data AI Privacy and Data Security Regulations session with Melissa Krasnow. Melissa Krasnow is a partner at VLP Law Group LLP, who advises organizations on domestic and cross-border privacy, data security, big data, artificial intelligence, governance, technology transactions, and mergers and acquisitions. Wow, very impressive, Melissa.
Thank you.
In this session, we will explore the impact of privacy regulations and data security regulations in 2020 on big data AI, including privacy policies and vendor agreements. More on the business strategy side of the conversations this is going to be. Now, welcome, Melissa. It's wonderful to have you here at our very first MinneWiADS conference.
Thank you, Diana, and thanks everyone who's attending. I will try not to disappoint because I've been reading the chat messages. And speaking of the chat messages, there have been some recent developments that you may have read about in the news. So on my mind, ransomware in healthcare, or regardless if you're in healthcare, I think it's a problem and it's pervasive. So California Privacy Rights Act, California Consumer Privacy Act 2.0, it's going to be voted on by California voters on November 3rd, which is this coming Tuesday, and it will be a game changer in privacy and big data and AI. So although I think Diana said, we'll have Q&A at the end, I'd like to make this session potentially a little more interactive. It's going to put more of an onus on Diana, but she said she's up to she's going to go for it, and she's up to this today. If you've got questions about anything, please put them in the chat. What I was planning to talk about was California Consumer Privacy Act and California Privacy Rights Act, and just in general, stepping back. If you think about this, there's lots of regulation. How does it impact the big data, artificial intelligence world? But put something in chat, and Diana, will ask, and I'll let you know if I know or how best to approach it. And in any case, January 1, 2020 of this year, before I think a lot of people knew or had realized anything about COVID, huge sweeping regulation went into effect, and I think really impacts big data and artificial intelligence. California is the 5th largest economy if measured separately. Almost 40 million people reside there. It's the most populous state. So organizations want to do business there. They don't want to usually not do business there unless there's a very good reason. So the reach of this law is great, and a lot of companies, including in Minnesota, elsewhere abroad, are actually ensnared. So I want to be very practical because I work with lots of companies on this, both in California and elsewhere, including abroad. What should you be looking out for with sort of through the lens, if you will, of big data and artificial intelligence? Number one, I think, is the definition of personal information. You may think you know what personal information is, but the definition's expanded. So you've seen in the past, maybe there's a distinction. Diana's social security number, for sure, that's personal information. That's pretty sensitive. Melissa Krasnow's image right now. In the past, that wasn't personal information. Under this law, it is. What about the internet protocol address? That wasn't personal information before, now it is. And what about internet activity? That could fall under this category. And really important for this crowd, inferences derived from personal information, which I think is key to big data and artificial intelligence. That's also defined under the definition of personal information. So what's a company to do if they find themselves ensnared? So the first question is, does it apply to your company? And it's a real important point because it either does or it doesn't. But I think also you may be asked by your business partners, if you haven't already, can you sign this letter agreement or this addendum? You're basically agreeing that you're going to totally comply with the California Consumer Privacy Act. Well, you don't want to enter into an agreement and for it to be inaccurate or false or misleading, right? So who does this apply to? It applies to companies with 25 million US in revenue. Is that California? Is that the country? Is that the world? That's not been defined. If you interpret conservatively, you'd say the world. It's not restricted to California, but it's everything. Okay, good news. My company is a startup. I don't have to comply, right? No, there are some other prongs. If you buy or receive for the business's commercial purposes, and commercial is probably what you think it is, not operational, but commercial, or sell or share for commercial purposes the personal information of 50,000 or more California residents. Depending on the nature of your business, and it may be you're a startup, but startups can have lots of data. Maybe you fall under this. I do know startup companies where they restrict this, and so they don't meet it. And then finally, do you get 50% or more of your annual revenues from selling? And this is California residents, personal information. Well, you must say, I know what selling means. Well, this law defines it differently. Selling, you may think, is for money. And that is part of the definition. Unfortunately, the definition goes beyond that and says selling or beyond or other consideration. Okay, so practically, what does this mean? Let me give you a great example. I work with companies. If you're subject to this law, you're going to have to update your privacy policy if you haven't already. What if you use analytics? Maybe it applies, maybe it doesn't. What if you use third-party advertising? Well, what if you are taking demographics and saying, we want an audience of these kinds of people, and disclose it, not sell it, disclose it to Facebook, hypothetically, to pick on Facebook. And what if Facebook gives you insights, but then uses that data? Big question, is this a sale? So this has been something that's occupied a lot of my time over the past year. With Facebook, the answer is it depends, and I'll explain what I mean. For most of the year, it probably was a sale if you interpreted things conservatively. A lot of companies, though, don't want to say, I sell personal information. So it's a disclosure, and Facebook may benefit. Facebook, is not getting money, your company's not getting money, but there could be benefits to both sides. I think conservative interpretation is it's a sale. Interestingly, in July, Facebook introduced some tools called limited data use. So essentially, at the beginning of July, it said to all its users, guess what? Default, you're going to be part of this. But at the end of this month, you've got to affirmatively say, I want to continue with limited data use. So what's that? That actually restricts the data regarding California residents. So it could be an interesting solution to, if you turn it on affirmatively, because it's after July, you may use Facebook advertising, but it kind of takes the California residents out of this. A lot of companies are actually confused by this, but I think it's an interesting solution. And if you use more than Facebook, perhaps other providers of advertising and similar services will have something, but Facebook is probably the most prominent example. So a lot of it's facts and circumstances, and one really important point. In the good old days, you would purchase advertising in a newspaper. So, for example, in Minneapolis, I would pay the Star Tribune to post an ad. Okay, is that necessarily advertising? That's a type of advertising, but if it's just posting an ad and there's nothing more, nothing else, it may fall outside the definition. All of this is subject to a lot of text. The law for this is 28 pages in PDF. There are regulations, they're 28 pages in PDF, they're different. So you add the two, it's 56 pages. It's too much. So if you are covered by this, you have a privacy policy, you have to update it for this. You've probably seen on the internet California Privacy Rights Notice or California Consumer Privacy Act Notice. That's what this is about. I think there have been some late changes and tweaks, and there's now more proposed regulations, but we have some certainty about what's expected. If you're looking around the internet, how can you tell whether a company has updated for this law or is subject to this law? So it may not be subject to this law, may not have to update its privacy policy. Really easy. Look at the date. Okay, I've got a question. Does CCPA restrict companies' use of mobile device IDs for targeted marketing? Doesn't restrict it, I think it regulates it, and in a nutshell calls for more disclosure. And when you use the word targeted, you use the word marketing, it may be advertising in the parlance of CCPA. Potentially there could be additional disclosure and obligations. But look at the dates of privacy policies. It's actually quite fascinating. So a couple key dates you should realize. January 1, 2020, the law, 28 pages went into effect. So first question to me is a privacy policy, does it have a 2019 date? Does it have a 2020 date? And then even further, the regulations, the final regulations, which are now proposed to be modified, they came out August 14th of this year. So look for an August, September, or beyond update date. In other words, that means someone has taken into account the regulations. They may have taken into account prior versions of the regulations, but the final ones came out on August 14th, and there were a few changes from how they were submitted. What I've noticed is a lot of companies have actually not updated for the August regulations. So, but this is sort of a quick and easy way. And this law is going to tell you how is the information collected? How is it disclosed? Is it disclosed for a commercial purpose, including targeted advertising? I'll use the word advertising. Is it sold? So if you sell information under this law, so for more than not just monetary, beyond receiving others, you have to put a link on your website. It's called "Do Not Sell My Personal Information." You've probably seen this. I think if you look at companies in the retail and hospitality industry, it's in fact rarer that they don't sell information. I think that's an industry which they don't make any pretense about it. They sell information. For example, they have loyalty programs. So if you think about it, they're collecting, maintaining, using, disclosing information for lots of good purposes. They're now, by this law, being called upon to disclose it, and potentially, if they sell it, offer the consumer, which is a California resident, the opportunity to opt out. So look for that "Do Not Sell My Personal Information" link. A real key point, and I've seen this happen, what if a company says in its privacy policies, yes, conservatively, we may not agree, but California may say we're selling personal information, so we're going to disclose this. What if they don't have the "Do Not Sell My Personal Information" link? They need to do that. I've seen that happen a couple times, so it's another really important compliance point. Okay, so just when companies have gone through all of this, updated their privacy policies, they also have to have contracts depending on their role in the ecosystem. Are they the covered business? Are they a service provider? Well, you must say, I know what a service provider is. Well, under this law, service providers use the personal information they get from the business, but for a business purpose, not a commercial purpose. And both terms are defined. I call it more of an operational purpose, and they will not sell or disclose data to anyone else. If you provide services, do you really fall in this definition? Well, there's a contract provision that's required if you are. If you aren't, there's another definition, it's third party, it's comparable to the service provider. It actually includes more sort of I won't disclose or sell personal information, but really interestingly, it's defined in the negative. So it's not a third party, so you don't sell information. But if you do, you are a third party, so that's kind of a giveaway. But companies have been sending contract amendments and letter agreements back and forth all year, including at the end of last year. So another real key point is this is requiring companies to update their contracts. And the way contracts are drafted, it's not the way this law states about not sharing information with third parties, particularly in the big data, artificial intelligence. system. There's a whole ecosystem, and contracts are unique, but they're not supposed to restrict or impose so many obligations on data. The California Consumer Privacy Act does. One other practice point, which I find interesting, I am finding business partners are sending around contracts and they're going beyond the requirements of the law. One great example is, in addition to saying you're not going to sell information, you're going to delete, destroy, get rid of information. While a really good practice, this is technically not required by the law. So be careful about what contracts your company enters into. And a lot of times, and particularly with MinAnalytics, what I'm fascinated, I'm one of the rare lawyers who's at these events, and I love that. Whenever I see someone from a particular company, I say, oh, I know this person in your legal department. The two of you don't know each other. So another kind of practical tip, I really wish, and I've made introductions, I really think folks here who are actually working on the big data, the data science, the artificial intelligence, they should begin to know their legal and compliance folks at their companies. I think it would be really enlightening for both sides, but I'm happy to make introductions in any event. But that's another point, because I think there are two different worlds, but whether they're working together is another question. And perhaps over the course of the past year, they are. Okay. All right. So what's going to happen? Today is Friday. I mentioned there's another initiative that's going to be voted on in California, along with other important elections. So Tuesday, November 3rd, while it's there's lots of elections in Minnesota, what's really on my mind is something in California. So voters are going to determine whether the California Consumer Privacy Act is amended. Okay, so why is this a big deal? Well, the California Consumer Privacy Act was the idea and brainchild and passion of a privacy activist, actually a real estate developer named Alistair McTaggart, who absolutely, I'll use Facebook again, he really hates Facebook. And so everything that Facebook does in terms of sharing, selling, monetizing, disclosing data, he just doesn't like it. He feels violated. And what he wants to do is have a really stringent law restrict or make it really difficult. I am not anti-privacy, but I think this law was really intended for the Facebooks of the world. I question whether it was intended for not every startup. There's probably a handful of startups in this area, but a lot of smaller companies have a lot of challenges meeting it. I think bigger companies with more data actually have their own set of challenges, and I think there's a huge organizational challenge if everyone is aligned and actually progressing on compliance, but that's another discussion. So what he did is he was unhappy with how I think companies are interpreting and complying with the California Consumer Privacy Act. He sees some loopholes. So he got in the hundreds of thousands of Californians in the middle of the pandemic to sign an initiative to put on the ballot. So the law, the text is there. Guess what? It's like 56 pages in PDF. And it's in a red line on PDF that was submitted to California government. So you may have seen in the news, this person, like former presidential candidate Andrew Yang, wants this to pass. Others, like some law professors and most privacy practitioners, actually don't want it to pass. Why? The reason is it imposes even more obligations on companies. So I told you the definition of personal information in the California Consumer Privacy Act was expanded. Guess what? This adds another category of personal information, sensitive personal information, and it is what you think of it. Health information, biometric information, I could go on, and I'm happy to provide you information. You can email me, you can look me up on the internet, I'm on LinkedIn, and I'm happy to provide additional information on this law. But sensitive personal information is treated even more stringently and has to be called out more. So be aware of that. Is this initiative going to pass? Well, it's a majority vote. There's been a lot of editorials in favor of it. Polling shows 80%. You don't know until the vote is over, but I think most privacy practitioners are expecting this to go in effect. So what happens? Well, if it passes, you're going to have to update your privacy policy again. And all the definitions of business, service provider, third party are changed. They now have new contract requirements, and a third definition is added. I noted that sensitive personal information is added as a contractor. So it will apply to businesses, service providers, third parties, and contractors. And there are multiple contract requirements. The good news is, if it passes, it won't go into effect until January 1, 2023, which is a ways away. The bad news is, and I feel companies have just gotten through updating, or maybe are still updating for the existing California Consumer Privacy Act. But this initiative will tighten things up. I think it's going to add a lot more compliance burden. So, Diane, I'm going to pause here. Are there some questions?
Yeah, so this is a great conversation, Melissa, by the way. And
thank you.
So let's say these big organizations, the big businesses, they have their own lawyers, they have their own privacy compliance teams to help them out. But with the big data and all the data science hype going on right now, there are a lot of people thinking about starting their own startups. And honestly, let's say that I want to do something like that. I don't have the knowledge or the expertise to keep up with all the regulations, and then that get changed. What do I need to do? What is your advice for someone starting a company, and how do we need to think about the privacy, data security, and all those regulations now than waiting and get into trouble? So what is your advice?
That's a fantastic question. And my law firm, by the way, is based in Palo Alto. So I work with startups. About a little less than half my work comes from Minnesota. I work with startups in California, New York, Canada is 20% of my practice. So what I've seen, and I'm going to speak generally and not identify, startups don't have an internal person, number one. You're absolutely right. Second, they don't have the budget to spend on outside legal spend. So here's how they've been addressing things. They're not the first to do the update. It's usually the big company. And the strategy, and I'm not opposed to it, because, as I said, it upsets me that small companies, for the most part, are treated similarly, although there are some changes that differentiate, but it really, the burden is pretty much the same. They're fast followers, so it's taken longer, but for example, I work with startups. My rate is negotiated client by client, so I can offer a lower rate. So I've been speaking with them. They haven't necessarily started, but we've continued a conversation. I provide them updates. I think they've got to find a good legal counsel and good resources to follow this. And then I think there will be a point where they'll need to do the update, and they're waiting until, so for example, I've done this so often, it will take me less time now, including the regulations, to do it now for a startup than it would have in January, and then saying, guess what, you're going to have to update for the regulations. So some startups waited for after the regulations, and then we negotiated. It would not be perfection. It may not be as extensive as a large company, but something that will be good, that will keep them out of trouble, and very practical. So I think it depends, but I think there is sort of a point. It may be the business partners are saying, enter into this agreement. And as I said, if you say we're complying with the California Consumer Privacy Act and you don't have a privacy policy on your website, or you have an older one, or there's no mention of California in your privacy policy, that might not look good. So why is this important to a startup? If you're trying to get funding, your venture capitalists, if you're doing it that way, or friends, they may be asking. Second, you may be entering into commercial agreements. Everyone has commercial agreements where you're asked to say what you comply with, and this is a big one. And that's another reason I think you might pay to update. And then last, if you are getting acquired, it will come up in due diligence, particularly if you're getting acquired by a larger company. So I'm seeing provisions in the merger agreement already extensive. It's probably From probably 20 to 100% increased what is being said in a merger agreement. So I think there's a point, but work with counsel and stick around. And not all of my startups have updated. And I let them know. I'll tell them, well, I think, this is your risk. It's your risk to take. But for the most part, I like how they're approaching this. The other thing is, and again, not to larger companies, they may have their own people internally. Whether it's being done correctly is another question. I think the benefit of outside advice is I get to see a lot of different companies and how they're doing things. I can counsel independently and say, this may be difficult, but we've kind of got to go through it, which is not what every in-house attorney says. But once we get to the conclusion, if there's a comfort level, that's something to hang your hat on. You've gone through a lot of work. So I think it depends, but it also depends on how much business comes from California. If you're a startup, for example, in Minnesota, and right now, even though Californians may use your website or mobile app, maybe you're assessing the risk. If you're based in California, or if that's a huge market, that's another question. One last point. I was noodling this yesterday. So far, there's been enforcement. Not all of it's been revealed publicly. I am waiting for the first action of the California Attorney General against a startup, because I think there will be larger companies. I'm interested, like, what kind of a statement are they making to startups? Should you really be, we understand you're a startup, so we're not going to enforce, or we're going to enforce against a startup to send a message. So that would be something to look out for in terms of risk. And we don't know that yet, but my eye is on that particular issue.
Thank you, Melissa. I appreciate it. We have a few more questions in the chat window. Someone asking, how can an ecosystem or infrastructure be created that people whose data gets used for training AI algorithms can get benefited to? For example, some kind of a revenue sharing, let's say patient data in healthcare. Also, to what extent hospitals are able to sell this data after some kind of anonymization?
That's a great question on so many different levels. So one point, the California Attorney General recently enforced against a women's health app mobile application, not at all California consumer privacy related, but it was a privacy. So it signals an intent to look at anything health related. So that's number one. Health is considered sensitive data. So a great question that I didn't cover yet in my presentation, but now I get to, so thank you for asking. Under the existing California Consumer Privacy Act, there are two exceptions to the definition of personal information. One is aggregate consumer information, the other is de-identified. Under the de-identified, so it's not anonymous, but it's de-identified. So if you use the words aggregate consumer information or de-identified in your privacy policy, it had better be correct if it's for the California Consumer Privacy Act. As a result, if a company isn't sure, I've been using the word anonymized or anonymous because that's not defined, just saying. So those are both defined terms. When you're talking about selling in healthcare, you're talking about two heightened risks. But if you're talking about it being truly de-identified or aggregate consumer information for purposes of the California Consumer Privacy Act, that's better. Another really important point is this a HIPAA regulated entity or not? And is it an entity that's regulated under the California Medical Information It's the California Medical Information Act. It's a confidentiality act for California. So it's different from HIPAA, but if you think about it, it regulates healthcare information. Finally, there was one amendment, well, there were actually two, but one amendment to the California Consumer Privacy Act that went into effect at the end of September, AB 713. I've written an article about it. So what does it say? It talks about health-related information and being de-identified and being carved out for, like, accepted from the California Consumer Privacy Act. However, de-identified information can be re-identified. It also provides for that, and if it gets re-identified, it goes right back into the California Consumer Privacy Act. So just So that raises, it's a question that I think is an emerging topic under privacy law. We always talk about de-identification, but we don't, like, what if it's re-identified? I think that's going to be further defined. And then the other really important point, so end of September, amendment to the California Consumer Privacy Act, it's law. If you sell health information, I'm speaking generally, you've got to have a contract about it. You've got to have and it's got to be starting January 1, 2021. So yes, this is really regulated. I will confess it's a challenge keeping up with everything. And I think it's creating sort of a group of practitioners who really knows this, just because there's just so much going on. But this was, if this person and anyone else is interested, I have an article about this AB 713 about de-identifying, re-identifying information. And oh, by the way, if you sell this information, you have to disclose it in your privacy policy, another obligation. But I've got an article which I'm happy to send to you. Please email me, reach out to me. I'd be happy to send it.
Thank you, Melissa. And there's another question in the chat window, and this is something I was curious about too, especially during this COVID season. There were apps some people found, and then using these apps, you can identify people where are they located. So there's a question about, are there any specific laws or regulations related to geospatial and location data management?
Yes, that's a wonderful question, particularly for this audience. And yes, and it's regulated piecemeal. And the theme is it's actually getting more regulated. It's also been the subject of enforcement actions by the Federal Trade Commission and some state attorney generals, not Minnesota yet. Although if you look at Minnesota Attorney General's enforcement, it's not exclusively, but it's the big data breaches and it's healthcare. That's what our Attorney General. So this is piecemeal regulated. Let's not take California Consumer Privacy Act into it. You have to disclose it in your privacy policy. You've got to talk about potentially consent to this. And you can't kind of bury it. You've got to actually do the opposite. You've got to call it out. And just because the product or service is free, that doesn't make a difference. You still have to disclose it. Like, in other words, if it's free, someone's not paid for this, I can do, no. Geolocation information is considered sensitive information. Uber got enforced against about this, interestingly. It's one of the Uber things you may not be top of mind because Uber's gotten enforced against for lots of different reasons. But yes, they were enforced. So this is on regulators' minds. Now, California Consumer Privacy Act, this is personal information, probably not a surprise. California Privacy Rights Act, the ballot initiative, this is sensitive information, sensitive personal information. I'm just going through my notes here. There we go. Yep, this is consumers' precise geolocation is how it's defined under sensitive personal information. So if the California privacy, so this is getting more regulated, and this is definitely of interest. So for example, mobile apps, you have geolocation. I think you do, even if you just have a website. The question is whether it's a precise geolocation or it's more general. But yes, this is regulated. If you add other sensitive information, so I'll give you an example, children's information or anyone under 18, 16, or God forbid, 13, or if you add healthcare information, like I just said, the California Attorney General enforced against a woman's health mobile application. That was part of the enforcement action. So you stand back, you look at all of these different laws and enforcement, and you're like, this is actually pretty regulated, but it's not in one place. It's disparate. And by the way, the New York Attorney General, which is I think actually the most active privacy enforcer, they enforced against health mobile apps and talked about re-identification and talked about geolocation also a number of years ago. So but I see more frequency in terms of regulation. There was a state law, it did not pass. It was in Illinois regarding geolocation. It didn't pass, but sometimes states come up with laws they don't pass and then they attempt to pass again. So we'll see about other laws, but California definitely regulates.
Okay, thank you, Melissa. And then there's another question. How do you implement data security along with self-service analytics for large global companies that lack proper intake and data governance? Where do you start?
I think the question almost answers itself. So I'm going to say things broadly. This is a huge issue, and I'm going to get to raise something that I wanted to raise. You may have seen in the news ransomware against hospitals and healthcare providers. It's targeting, it's already hit some hospitals, including, I believe, one in our state. So the California Consumer Privacy Act, California Privacy Rights Act, it's got privacy, it doesn't have security, but wait, how can you sue someone under the California Consumer Privacy Act? Lack of reasonable security, and it invokes another California law into that definition. So there's been lots of private lawsuits. Whenever a law gives someone the ability to do a lawsuit, a private lawsuit and sue, I think there's a role for plaintiffs' attorneys. They will take advantage of it because there are not every law gives them that right. So they're taking advantage of it. So in a nutshell, if there's a breach, which is the bad outcome, and it could be not at all the fault of the organization or not great security or lack of governance, lack of data governance and intake, et cetera, could have been a contributing factor. It's making it more likely for there to be a breach. I have noted working on more breaches during COVID. Interestingly, none of them are COVID related. They would have happened anyway, but many of us are now at home and having to work remotely with other organizations and managing a breach. It makes a breach more likely. So why is that important? It just heightens your risk of getting sued under the California Consumer Privacy Act. Okay, California Privacy Rights Act, it makes the definition of security and defines a type of breach even high. It's a higher threshold. So it's upping the ante for compliance in terms of this. So I look at these laws actually as data security laws. The other thing I'll mention, and it's a trend, whereas 50 states have breach notification laws, unfortunately, if you get a letter in the mail or maybe an email, we're really sorry this happened, our systems were compromised, we're going to offer you maybe credit monitoring. I work with companies, unfortunately, I get these letters and I have the same feeling as probably I feel violated, I'm upset. And I got, the irony is I've been working on breaches and I've been getting letters from other organizations impacted by the same breach and as an individual or consumer, and it's really upsetting. Other states, over 20 states have, I'd call them reasonable security laws. Minnesota does not. California has a separate law. New York has a law. It's called the SHIELD Act. It is not getting the press of California, but New York is an important jurisdiction and they've got a really active attorney general. It calls for companies to have a data security program. That's key. And it's got to be a New York data security program. The most notable state for a data security program is Massachusetts. Between New York and Massachusetts, there are different requirements. There is a little bit of overlap, but they're substantially different. Your company should have a data security program because you're probably putting in contracts things about data security. And if you don't have a program, what are you saying in your contracts? I mean, the things that are being asked for in contracts are often part of a data security program. So that's another area. Or you're being asked from your business partners to say, we have this level of security. So this is an area not to take your eye off. Unfortunately, I think there will be more breaches. So I mentioned ransomware. FBI, Department of Health and Human Services, and CISA.gov, which is overseen by the DHS, the Federal Department of Homeland Security. Ransomware attacks, if your hospital hasn't been hit first, there's an imminent threat to healthcare providers and hospitals, and talked about best practices, talked about how to detect and respond. So ransomware, I think, is a threat. I think with big data, this would be encrypting the data in the systems. Is your organization prepared for that? What I've been telling companies is do hypothetical simulated exercises of a ransomware attack. It's called tabletop exercises. It's actually very fun to do when you're not in a crisis situation because you realize what you haven't thought through or even addressed. Bring in someone from the FBI if you're able remotely, or the Secret Service, which you can do, by the way. Bring in members of your team. But ransomware is particularly awful because whereas you respond to just a breach or an incident regarding security, ransomware, you have to decide, are we going to pay the ransom? Okay, so what's the point of that? Well, first of all, law enforcement has always said, and they're now emphasizing, don't pay the ransom. What if it's a hospital? What if a patient's life is at stake? Or seriously, is the hospital or the healthcare organization, are they not going to pay the ransom? It's a case-by-case decision. And I don't think there's a correct answer. If the ransom is paid, here's what's happened. On October 1st, OFAC, which is part of our Treasury federally, said, you know what? These bad actors in ransomware scenarios, they could be on our sanctions list, either countries or individuals, and you don't know who you're paying in ransomware. And if it's one of them, that could get you in trouble and you could be violating sanctions regulation. Number two, the Financial Crimes Enforcement Network, which is part of AKA FinCEN, which is part of the Federal Treasury Department, said, you know what? If you're using a financial intermediary, it could be a bank, it could be a forensics firm offering a Bitcoin wallet, it could be an insurance company. If you're paying the ransom in cryptocurrency, which often is demanded, the financial intermediary may have to report it to the US government under the Bank Secrecy Act if they're a money services business, even in particularly if it's cryptocurrency, but otherwise, but usually this is asked for in cryptocurrency. Finally, CISA.gov, CISA, issued a ransomware playbook and guide. Again, I'm happy to send you all of this information, but if you think about it, the decision to pay the ransom just got more complicated. It could be against the law. So if it's against the law, is your financial intermediary going to be willingly say, I can get you a Bitcoin wallet? Maybe not so much. And then if you've got cyber liability insurance, are they going to reimburse your costs? And this is a question I've been noodling. If you're doing something that might be against the law, paying the ransom, and it could be violating sanctions. So I'm advising, and I've been doing this actually through most of the year because these attacks have been going up, particularly in our remote environment. Mm-hmm. But this is an area to continue to watch.
Thank you, Melissa. Thank you for the wonderful presentation and very insightful conversation. And thank you all for joining with us today. We will see you all at the next session. Bye-bye, everybody.
Thank you. Bye-bye. Thanks, Diana.
Thank you.